Thank you, Lauren, and thanks for inviting me to speak today. Now, as mentioned, I am a solicitor. I'm a lawyer. So there is some quick disclaimers, okay? Things that I've got to let you know. The first is that the purpose of this session is not technically legal advice. It is legal information. If something comes up in the discussion that you think I've got some very specific questions about my circumstances or something to do with me that I'd like to get some advice about, I do encourage you to contact Peninsula Community Legal Centre and ask for an appointment, and then you'll get formal legal advice. We can see what we can do to assist you. So, as said, I'm talking about a couple of things today, and I'm going to break them up into two sections. The first is going to be about wills, and what a will is. I start with some basic things and then talk about some other things that you may have heard of but maybe not understand. So things like executives, probate, those kind of things. And then talk about powers of attorney and advanced care directives, and also a little bit about guardianship because they're all related. So we'll jump in talking about wills first. So I guess the question we often get is, why should I have a will? In short, a will allows you to essentially plan ahead what will happen to your property when you pass away. It is a way to ensure that your assets, so what you own, ends up in the right hands at the right time. It can also be a way for you to provide for any vulnerable beneficiaries that you might have, so family members, and ensures that your estate, so what you own, can be protected. So it doesn't get broken up and it doesn't get sold off to people that you may not want it to be sold off to. There are other things that can be put in a will that are a bit more complicated. Generally for people that have a significant amount of assets in their estate of a really high value. You know, if you've got a lot of money and you own a lot of property, there are issues in terms of how you can maximize the benefit to your beneficiaries. But as I said, I might not go into that in too much detail today. Another question that I often get asked is, well, what happens if I pass away without a will being in place? If you don't have a will, it's called intestacy. Okay? And intestacy is essentially a formula that distributes your estate to your next of kin. Now, if you have very few relatives or very few next of kin, and then it may not really make that much of a difference whether you have a will or not. But I would encourage, even if you are in those circumstances, to consider drafting a will, because the problem with intestacy or passing away without a will is you don't have any control over what happens to your property when you pass away. It just gets kind of allotted out in this very kind of straightforward formula. And also assets that you may want to keep in the family may be sold off to pay for debts and things like that. When, if you do a will, you can be more specific and decide what happens to particular pieces of property rather than it all just forming part of a big pool. So what do you need to think about when you're thinking about drafting a will or having a think about, well, do I want a will and what should I include in it? So the first thing is you've obviously got to be over 18. Okay. Now, another thing that you've got to have is what's called testator capacity or testamentary capacity. And that essentially means that you've got to be doing it upon your own free will and have the capacity to understand what you're doing. Okay. Then it needs to be in writing. You can't just tell someone what you want to happen and say that that's a will or record it. It needs to be in writing. And there's also needs to abide by certain formal requirements, such as it being signed by 2 independent witnesses who are present at the same time as when you sign the will, and who are not beneficiaries of that will. Okay, they need to be 2 independent. Now, if you're drafting a will with a solicitor, it'll often be the solicitor and someone else, their assistant or someone like that, who will often witness the will. But it can be friends, assistants, workers, people who are willing to do that for you. Now, what are the things that you should make sure that you include in a will for it to function correctly? The first is you need to appoint what's called an executor. I'll go into in a little bit what an executor is and what they do. But really the way to do it is to think about what property you have, think about how it's owned, and that really relates to if you own a house, you can own a house in a couple of different ways. So you want to figure out, well, how do I actually own this house, and do I own it with someone else, and how does that work? You can then think about, well, who am I going to specifically give my property to? So think about who should be the beneficiaries, and then think about if you've got children or grandchildren, for instance, how am I going to distribute my benefits to people who aren't yet 18 and therefore may not be in a position to manage the benefit of the property? So you can even create what's called a trust in relation to a young person who you may not want to give all your benefit to. And that essentially allows for a guardian or parent of that person to manage that money or that estate, or invest that estate, to hold it in trust for that person for when they become 18. And you can also hold benefit for someone who maybe doesn't have capacity, or someone who is potentially disabled, and therefore you can essentially have it so that they may not be in a position to manage the funds themselves. You can hold the benefit of the your estate on trust for that person. Okay. So one of the things that you can't include is, as I mentioned, sometimes there's certain type of land that you can't include if it's owned in a particular way. That's if it's owned with a right of survivorship. So there's a way you can own a property where automatically, if you pass away, it goes to the other person. You don't need to put it in a will. So you can't also certain bank accounts, and this one comes up a lot, superannuation or life insurance policies. So that's if you do have a super fund that has a lot of money in it, and you want to figure out, well, what happens to that money when I pass away? Actually, a lot of super funds have different policies in relation to this. So it's obvious, sometimes it's better to just contact your super fund and say, well, what's my fund's process? And they'll be able to talk you through what you do in those circumstances. Also, if you have property that's owned by a company or owned by a trust or is held by a trust, then obviously you can't, that's why I mentioned figuring out how something is owned. You can't gift something that you don't own directly in your will. So you can, so that's something to consider if, for instance, you own a business or something like that. So I mentioned before this term executor. So what is an executor and who should I appoint as my executor? So an executor is the person, and it's kind of in the name, that executes the will, as in they make all this stuff happen. They've been appointed to distribute and manage the assets that are in the estate. They essentially are the person that is appointed to effect the will, to make it happen. You can have multiple executors, joint and several executors. You can even appoint an alternative. So if the first person you appoint is not available, then it can fall to an alternative executor. Now, the first thing you want to do if you're thinking of appointing someone as an executor is to have a conversation with them. Let them know that you're considering doing this, and that they're willing to undertake the role, because you don't want someone to be surprised that they're going to be your executor. You want them to be aware of your appointing them. They should also be someone that you trust, and they should be someone that is capable of fulfilling those duties, because it can be a complicated time when someone passes away, and they've got to be able to act impartially in the best interests of the beneficiaries. They've also got to arrange the funeral, they've got to list and preserve all the assets, and they've got to notify banks and agencies in relation to your passing, pay debts, arrange for the funeral expenses, duties, taxes, all those kind of things, as well as distributing the assets to the beneficiaries. So it's got to be someone that you think is going to be able to do all those things, or a team of people that are going to be able to do all those things. Now, another term like executor, or that you may have heard when talking about wills, is what's called probate. Now, the reason why probate comes up a lot is because that's when, at that process and the kind of probate stage in relation to a will, after someone has passed away, is when people often challenge a will and say either this will isn't the last will that they wrote, or this, I should have been included in this will, or I'm not getting what I was promised, that kind of thing. So essentially, a probate is where the court, so the Supreme Court in Victoria, says this will is legitimate and lawful, and grants a certificate to the executor that allows them to then distribute the property. Okay. Now, obviously, the requirement of having a grant of probate depends on the amount in the will. And so sometimes if there's not a significant amount of beneficiaries, or there's not a significant amount in the estate in terms of its value, how much money is there, you might not necessarily need to have a grant of probate. That's the kind of thing, if that happens to you, contact a place like Peninsula Community Legal Centre, make clear what your what the assets are, and they may be able to tell you whether you're required to get a grant of probate or not. Now, as I said, once what's called letters of administration have been issued, they essentially allow the executor to deal with the assets that form part of the trust. So essentially, it allows them access to their bank accounts. It allows them access to the home. It allows them access to their documents, to all their assets, for then the executor to distribute to the beneficiaries, to the people that the person in the will has said they want the property to go to. Now, I mentioned that at that stage, a lot of challenges occur. So you can, if a relative of yours passes away and there is a will that you say that you disagree with, you can challenge it. And some of the reasons for why someone would challenge a will are duress and pressure. So you say that the person created the will under duress, that they didn't want to make the will, but they were forced into making the will. That it's a forgery. It does happen that people forge wills, saying, well, that actually this is a new will that has been forged and gives me all the benefit. That it is not signed or witnessed properly. So that sometimes happens as well, where it hasn't gone through all those formal steps that I mentioned earlier in terms of being witnessed and signed correctly. There may be a dispute about whether the person had capacity to make a will at the time of the making of the will. In circumstances where, say, they're suffering from dementia or Alzheimer's, there may be a dispute about whether the person had capacity to make a will at the time of making the will, or someone produces a will that is later in time. Now, the reason for that is whenever you make a new will, one of the first things it'll say is this overrides all previous wills. Okay. So if you come to the court, to the Supreme Court with a will that was made in 2020, and then another person comes along with a will that was made in 2022, the will that was made in 2022 will override the will that I had in 2020. Okay, so that means that the other will is the one that the court will make effect to. So another one that comes up quite a lot is where whilst the courts won't usually interfere with a will because they want to respect the wishes of the person that has passed away, they can and will interfere with a will or the distribution of the estate if it doesn't look after the needs of someone who the court considers they had a duty to provide for. It's called testator family maintenance. It's essentially, so I'll give you an example that might give you a better understanding of how that works. So let's say that there is a person that has a child who has lived with them for their life. They've both cared and supported each other. But let's say a couple of weeks prior to their sudden passing, they had an argument, and she went out and changed the will to remove them from the will entirely. That person, quite rightly, because of their ongoing relationship and support they provided to each other, could reasonably expect that they would be a beneficiary in their will. And so if they were to challenge the will, they would likely, that the court would likely say, well, it was reasonable considering their relationship up until a week or so prior to the drafting of this will, that they would get some benefit. It can also be in circumstances where you have been receiving a benefit. So let's say that a relation has been paying for your rent over this period. You may expect that the will would continue from the estate to allow you to continue to have the benefit of that. So if you're in a situation where you are a close relation, that you've had a close relationship with, but you're not included in a will, you may have some grounds to challenge that will and say that I should receive some benefit if you have been receiving a benefit in the past. So in terms of, that's kind of the challenging of a will and a bit about the process. So I guess the next step is some of the more practical concerns in relation to making a will. How do you go about actually doing it? Well, A will doesn't necessarily need to be written in formal language or legal jargon, as long as your wishes are clear. Now, there are ways that you can, essentially, they're called do-it-yourself estate planning documents that allow you to engage in estate planning with minimal cost. Essentially, you can download a form from the state trustees and fill out that form, have it witnessed and signed, and then you've drafted a will. Now, the downside of that is that, well, the upside is that cost doesn't cost you anything, and you won't need to worry about paying for a will or storing it or anything like that. But the downside is if there's some problem with it, then you'll fall into that intestacy that I mentioned before, where you'll pass without a will. Now, obviously, sometimes the court will take into account a incorrectly drafted will, but generally, as I said, it means that you will fall into that intestacy and you'll lose the benefit of being able to decide what happens to your estate. So the most important thing about if you're putting together a will is to make sure that it's properly drafted to reflect your wishes and is correctly executed. And as I said, if you're able to, my advice would be to engage with a solicitor to assist you with doing that, because then you at least know that you've done everything correctly. Okay, because it's really important that the lawyer makes sure that it's done correctly, because they then are liable if they've messed it up. And they'll also store it and things like that for you, put it on fancy paper and all that kind of stuff. Now, another thing is that we get asked a lot in relation to wills is, if I remarry, do I need to change my will? A divorce does override your will. It's no longer functioning. So if you are divorced or separate, it's a good opportunity to have a look at your will. Also, a question we get a lot is, well, what if I've got property overseas? If you've got a beneficiary that is overseas, or you can make your will in Australia, and then it's just the executor has to essentially ship or move that property, dispose of that property over to that person overseas. If your property is owned overseas, so let's say you have a house, if you're lucky enough to have a house in Italy or something, you would need to make a will in Italy in order to distribute that property. So the thing, if it goes back to what I mentioned before, how is that property owned? Because if it's owned in Italy and under Italian law, then you need an Italian will to distribute it. Okay, so that's why it's really important when you're thinking about your will. How is my property owned? Where is it owned? And as I said, you'll be able to sort that out. Now, in the last thing I will say in relation to that is there are international wills. Listen, it's not something that I would encourage you to that I don't think anybody would need to engage in. That's really for people if they've got multiple international properties. They can draft a kind of, there's a UN convention about a specific will. Only certain countries are signatories to it. Last thing I'll say also is that some of the Commonwealth countries will recognise the wills of other Commonwealth countries. So, for instance, I believe New Zealand and Australia, for instance, even the UK will recognise a will drafted in Australia. So that's kind of the section that I'll do on wills, and then I'll talk quickly about advanced care directives and planning. So, in relation to, similar to the making of a will, advanced care directives and powers of attorney are really about planning. Okay, planning for the future. and giving you control about what happens in relation to the future. Whilst wills is about what happens to your property after you pass away, power of attorney are about what happens to your kind of finances and legal decisions whilst you may be still alive but have lost capacity to make those decisions. And advanced care directives are about what medical decisions are made if you lose capacity. Okay. So what is an advanced care directive, and what is appointing a medical treatment decision maker? So in the past, and some of you may have had one of these in the past, you used to appoint a medical power of attorney, and they would make decisions in relation to your medical treatment if you are no longer able to make those decisions yourself. Now, in 2016, that changed to the current system that we have. And there are essentially three key things that changed. The first is it allowed a person to not only appoint someone to make decisions, but it also allowed the person to create what's called an advanced care directive. That is a document that allows you to direct the decision maker, so the person that's going to be making decisions, about what kind of treatment your preference is. So if you prefer a certain type of treatment or you don't want a certain type of treatment, you can put that in your advanced care directive. And your medical treatment decision maker, except for in very specific circumstances, such as an emergency, is bound by what you wish to be, how you wish to be treated in terms of your care. So it's really important when looking at doing this to have a conversation with not a lawyer, but your doctor. Because your doctor is going to be in a better position, or a nurse or the like, is going to be in a medical practitioner is going to be in better position to advise you about the kind of care and options that are available to you than a lawyer will. Because a lawyer is going to, what do I know about medicine? Very little. Now, the next thing that you're able to do is a bit more broad. It's what's called a values directive. And whilst it's not like the instructional advanced care directive, it's not specific about what kind of treatment you're going to be receiving. It's much more about what are your values, and what, in terms of your values, kind of treatment would you prefer? Are there religious issues that need to be considered? Are there philosophical issues that need to be considered? Are there things that you, values that you hold in terms of the kind of treatment that you prefer and what you wouldn't? This also connects with the assisted dying legislation as well, in that you can put in your care directive and your values directive about resuscitation, about being on certain types of, if there's a certain degree of brain functionality, that kind of thing, where you can decide that, no, I don't want certain types of treatments in certain situations. Now, both in terms of the advanced care directive and the values directive, your person that you appoint as your medical treatment decision maker is bound by those decisions. Okay. Now, and what you put in those directives. Now, the last thing I should mention before I move to powers of attorney, when it comes to that third thing that I mentioned, that is a support person. So you can appoint through a advanced care directive a support person who can essentially attend with you at your medical appointments, have access to all your medical information, and assist you in making decisions about your health and your health care. They don't have the power to make decisions, but they're there to essentially help you make decisions about your treatment and about your treatment options. So it's often, I think, a good idea to have the same person as your decision maker for when you lose capacity to make decisions, or if you lose capacity to make decisions, being the same person as your support person. And the reason for that is that it means that they're aware of, if they've been supporting you for some time in making treatment decisions, they're going to be aware about what your medical issues are, and they're going to be more aware about what your preferences are and what you hope to happen in relation to your medical treatment. So similarly, let's talk about the practical side of things. Who should you appoint as a medical treatment decision maker? Again, someone that you trust, someone that is capable, and someone that you've had a conversation with about being in that position. Another question is, well, how do I go about putting together this document? As I said, the first port of call would be your GP, and just say, listen, I listened to this this lawyer talk about medical treatment decision making, and I'm interested in putting together a plan. Some GPs actually will quite literally pull out the document and go, let's put it together, or they'll refer you to specific services. I do know, I think we've got some people from Penn Health here. I'm not sure what happened, whether that started up again since COVID, but I recall that there was a service that essentially nurses from Penn Health would assist people with producing their advanced care directives. And I know that at Frankston Hospital, for instance, they also had a service that essentially by appointment would assist you with putting together your care directive. And the reason why health agencies and they're like, oh, that's great, we've got some confirmation that's still running. The reason why that's a really good way to do it, especially with Penn Health or your local hospital, is that they have it there. It's uploaded onto your file, and it means if there is an emergency or something like that, they're able to pull it up. They have all that information there ready to go. They don't have to contact a lawyer. They don't have to go through all that process. It's right there. It's a medical decision, and so really it should be with as I said, long waiting list, but you can see in the chat, but it is something that's worth waiting for if you haven't got that arranged, because as I said, it really benefits not only you, it benefits your medical treatment team, and as I said, it's hopefully means that you don't have to worry so much if something were to happen where you lose your capacity. Now, in terms of, as I mentioned, the losing of capacity, power of attorney and guardianship. Now, those two things are very intimately related, essentially, because essentially a guardianship really only occurs in circumstances where someone has never been able to appoint a power of attorney. Either they've never had the capacity to, or they're too young to appoint a power of attorney, or someone has failed to appoint a power of attorney and they suddenly lose capacity. So what is a power of attorney? Power of attorney is where you appoint someone to make legal decisions on your behalf. Now, legal decisions covers a really broad amount of decisions. Buying and selling things is a legal transaction. Entering into contracts is a legal transaction. Drafting things like wills, owning businesses, all these things, all these legal decisions can be made on your behalf by the person you've appointed as a power of attorney, but only if, in terms of an enduring power of attorney, only if you've lost capacity to do that yourself. So we get this a lot. A lot of people are concerned, well, I've made this power of attorney and the person started making these decisions. And I often say, well, the first question is, has that person lost capacity? If the person hasn't lost capacity and is still able to make their own decisions, then they absolutely should not, the person that has that power of attorney should not be going around making decisions yet. Because most powers of attorney only come into force if that person has, the person that may appointed the other person as a power of attorney has lost capacity. Okay. So essentially what you're planning for with appointing a power of attorney is either through illness or accident or otherwise, that you're concerned that if you do lose capacity, you're going to not be able to make those decisions anymore, and you want this person to make those decisions for you. That's why if you're in a situation where you do potentially have a degenerative condition, or you're elderly or otherwise, or perhaps you're in a dangerous profession, you can, it's a good idea to appoint someone as a power of attorney, just so they're able to avoid the next thing that I'm going to talk about, which is guardianship. So there have been some recent changes to guardianship in an attempt to try and make the process make more sense in a way. So in relation to guardianship, essentially guardianship happens when there isn't a power of attorney, but someone still needs to make decisions about someone who's lost capacity by accident, disease, or otherwise. And in those circumstances, you need to apply to what's called VCAT, which is essentially a informal court. It's called a tribunal, and they will appoint someone as the guardian. Okay. Generally, it is the closest kin or someone related to the party. And there can also be disputes about who should be the guardian. Some people will say, I should be the guardian, and perhaps someone else says they should be the guardian. VCAT then determines which of those people is more appropriate to be the guardian. Now, often what can happen there as well is that the person may, if there isn't someone who's able to be the guardian, their guardian may be appointed to be the state trustees. Now, that should only ever really be a last resort. And the reason for that is, and some of you may have had some dealings with the state trustees, they can be very difficult. It is a big bureaucracy. It's not that there's often concerns in relation to how funds are used. There's often fees. There's all sorts of things. There's some really quite harrowing horror stories in relation to people dealing with the state trustees. I always like to think that everyone's trying their best. But as I said, in terms of, it is really should be considered a last resort. And if you are able to appoint someone else to be your power of attorney, or if you're able to be someone's guardian, that's often a better, can be better. Now, in relation to guardianship, you as a guardian, you have.
I'm just in a meeting. Can I call you in 20 minutes?
Sorry, someone
Jamie.
just
Thank
received a call. Sorry.
Okay.
So in terms of guardianship, a guardian has very specific duties to the person they're the guardian for, and so does a power of attorney. Now, with those recent changes, it is actually a criminal offence in certain circumstances for the person to act contrary to the person they're the guardian for or the power of attorney for, to misuse those powers. So take money, they shouldn't use money on themselves rather than on the person they're the guardian for instance. So it's a really big responsibility, and you are bound by very specific things that you can and can't do. You have this duty to the person that you're the guardian for or the power of attorney for. Now, in terms of a power of attorney, similar to basically all the other things, it's about drafting a document, a legal document. Similarly to a will, it needs to be signed and witnessed. And similarly to a will, the state trustees have all the forms that you can fill out to appoint someone as a power of attorney. Now, and similarly to a executor or a medical treatment decision maker, if you are going to appoint someone as a power of attorney, it's worth considering, are they capable of doing it, and having a conversation with them about whether they're willing to do it, and discussing with them what your wishes are in relation to why you're appointing them as the power of attorney. The process of someone being appointed as a guardian is more complicated. As I said, it involves a hearing or decision at VCAT, and so that's a bit more complicated. If you're in those circumstances, then I would really encourage you to either seek legal advice or contact VCAT directly, and they'll be able to advise you. Essentially, you make an application to VCAT, and there's a form on the VCAT website, and you fill out that form, or you attend at VCAT, which is essentially the one down on the peninsula here is at the Frankston Magistrates Court, and you provide evidence in relation to the person's capacity, and fill out that form. And generally, as long as it's not contested, the court will. Let's probably just kind of reiterate one of the things that I kind of, perhaps a theme of what I was talking about, and that's really, with all these things, it's about planning, about thinking ahead, and about choosing people that you trust and that you think are capable of doing all the things that you want in your plan. Okay. And if you've choose the right person, you're about 80% there in terms of that planning. If you choose the right person to be the executor, they'll manage all the little things that come up in relation to your will. If you choose the right advanced care person in terms of your medical treatment decision making, if you choose the right decision maker there, they'll be able to make sure that you're the most comfortable and all your wishes are met in terms of your medical treatment. If you choose the right person in terms of your power of attorney, you won't have any problems with them making decisions that aren't in your benefit, that aren't in your interests. And similarly, if you do all those things, then you'll avoid the conflict that can come with someone being appointed a guardian. You'll avoid the conflict that can happen in relation to a will being challenged, for instance. So the first step in a lot of these things is to have a conversation with the people that you're close to in your life, that you trust, about these things. About, I'm thinking of drafting a will, I'm thinking about appointing a power of attorney, I'm thinking about a medical treatment decision maker, and having a conversation with them about why you're doing that and what you expect out of it. You know, that's a real practical thing. In particular about wills, you've got to think about a will often as not just how you're going to distribute your assets and in a real kind of technical way. You also want to make sure that when you pass away, your loved ones aren't fighting over things. So often have a think about a lot, your will in particular, as a way to manage conflict. If you know that this particular piece of furniture, for instance, is someone in your family absolutely loves it, don't leave it in the will to the cousin that they hate. You know, these are the kind of things, the kind of practical considerations beyond just the legal stuff that are really important when thinking about your will. Have a conversation with the people that you are going to be beneficiaries about what you're going to be leaving them, so that they know, and that everybody can kind of potentially have those arguments before you've passed, and you can explain why you've decided to leave this to this certain person. I'm sure some of you may have experienced a situation where a family member has passed, and that is an occasion, and a dispute about the will can be an occasion for families kind of tearing apart, and a lot of family disputes arising from that. And often that's not because of the actual property, you know. The credenza is not really what it's all about. It's actually about the kind of emotion that comes along with someone passing away. But you want to be able to try and minimize that by being clear about who gets the credenza and why. And, you know, those are the kind of things that will mean that when you do pass, though you minimize those things. And hopefully it's not something that, you know, people remember about you was, well, they didn't do a will and it caused this big blow up in the family. So that's one thing, especially with wills, that you want to consider. Similarly with powers of attorney, you can appoint multiple powers of attorney. It can be, I would encourage people to try to think about having odd numbers of these kind of decision-making appointments, simply so that they can do it democratically and it's not just two people just constantly arguing about decisions being made. But as I said, so more broadly, the things I would ask you to consider is the decision making in relation to who you're appointing. Make sure that there's someone that you trust and have a conversation with them about it before you appoint them, and that you're thinking about appointing them. Secondly, is think about this, especially your will, as a way to limit conflict. You want to try and plan, talk about these things ahead of time so that there's not a big fight in your family and amongst your beneficiaries. Sometimes you can't prevent it because, as I said, it's not about the property. It's not about what everyone's getting. But it is important to think about that. You know, you don't necessarily want to be. You can be very antagonistic in your will. As I said, you can really put what's the saying, a cat amongst the pigeons. But you don't want. My advice would be don't do that. Now, any questions about anything I've mentioned or talked about in terms of wills, advanced care directives and medical treatment decision makers, and powers of attorney and guardianship?
If nobody else has, can I ask first? I'd like to know firstly, is a medical treatment decision maker always a member of your family or care? Like, who's he?
Okay, so in case anybody missed the question, it was that does the medical treatment decision maker have to be a family member or a carer? And the answer is no. They don't have to be related to you for you to appoint them. They don't have to be your current carer or medical professional for you to appoint them. But I would say that it's always a good idea to appoint someone who is aware, or you've had a conversation with, and is aware of your medical needs. Because you don't want to be in a situation where, you know, you've got a friend who you love them and you see them maybe a few times a year. They live in WA, and you've appointed them as a medical treatment decision maker. But you live in Melbourne, and so if something were to happen, if there was an emergency and you ended up in the hospital, they may not be available to make decisions for you. They may not be aware about what your medication is or what your treatment needs are. and so they will either refuse to make those decisions and say, I'm not taking up the position, which someone can do. They can say, well, I'm not going to do it. Which is why, again, I say it's really important to let them know that you're thinking of appointing them as this in this important position, because you want to make sure that they agree to do it. Or they just may not be available to make those kind of decisions because they are either not available, or the other thing that happens often is they do take it seriously. They maybe even come to Melbourne, but then they've got to be caught up on all your medical issues and everything that's going on with you. And so that all that time is delay. That may be critical in terms of making decisions about what happens in relation to your medical care.
Can the benefit or the advanced care directive person be someone like one of your psychologists? So there's not really any other relationship than the one that's paid for? Could they be?
Yeah. So again, if someone, if you didn't hear the question, it was, can you appoint someone like a psychologist or a professional, and can someone charge for the medical treatment decision making? I think that was, again, the gist of the question.
Yeah.
Now, often professionals will say no, they're not going to do that, because, and sometimes they'll say yes. Generally, they'll make that clear for you if they're going to do that. In terms of charging a fee, I believe you can, but I think you'd find that I'd have to actually double check this, because I think there is some restrictions in relation to it being a paid service, and generally, from my memory, and as I said off the top of my head, I don't know whether you can engage someone privately to pay them to be your advanced care, your medical treatment decision maker. But so, as I said, it generally, the idea is that they are not necessarily need to be a professional or a medical professional or things like that. As I said, they're there really, like with a lot of these things, they're supposed to execute or do what you've told them you want to happen. That's their role. That's why the important thing often is them willing to do it, their availability to do it, their capacity to do it, and you trusting them. And if that person is your psychologist, or if that person is your doctor, or if that person is your friend who lives in WA, then they're the best person to appoint. The key thing is trust, because they're going to be making really important decisions for you, and you want to make sure they're going to be doing it in your best interest. Okay, they can learn all the stuff, be told all the things about the medical stuff, and they can catch up on that. But as I said, it's really important that you trust them. That's probably the first thing to consider, and probably the last thing as well. So I can see that someone has a question. I believe, is it Lambos?
Effie, yes. Hi, how are you?
Yeah, good.
That's good. Thank you. Thank you for your presentation. I just have a quick question, and it is context specific. So if you're aware that a power of attorney was in place for somebody, and then that person did go on to have a very severe brain injury following a motor vehicle accident, subsequent testing of that individual identified that they do have the capacity to make their own decisions, but the person that holds the power of attorney continues to make decisions for them, how do you communicate that the overarching decision maker is actually the person rather than the power of attorney? And do you have an obligation to, as the case manager, which is my situation, what obligation do you have to communicate to different stakeholders apart from sharing that in email? Is there like a legal process you need to do to ensure that everyone is aware that this person does have capacity?
This is a really good question. Really good question. Because this is actually something that has recently changed in terms of the guardianship legislation. One of the things that kind of came in with that is that the presumption is that everybody has capacity. So if someone comes in with a power of attorney saying that they want to start making decisions about certain things, and they say that they've got this power of attorney and the person has lost capacity, it's actually them that has to prove, by the providing with it medical materials, that the person that they're acting on behalf of doesn't have capacity. So you're well within your rights to say, well, I know you've got the power of attorney, but where is the medical evidence saying that this person doesn't have capacity? You need to show that they don't have capacity as well as provide the power of attorney. Okay, so you can't just go to a bank with the power of, and this is something that's actually really important, and perhaps is something that, you know, I've been trying to do quite a lot of, is relay that change. Because it is really important. A lot of people do, just when they're given the power of attorney, just say, well, okay, well, there is a power of attorney, not doing the follow-up question. Well, where's the evidence that the person that's referred to in this power of attorney doesn't have capacity?
And in my specific example, I think the discharge information, which identified a catastrophic brain injury, was deemed satisfactory, such that the bank now enabled the power of attorney to take over.
Yeah, and as I said, that's what I mean about, especially with banks and financial institutions, them not doing their due diligence in relation to that. Another option in those circumstances, if you're concerned that, if someone is concerned that someone they've appointed as a power of attorney is misusing that power, as I said, first thing that they can do is revoke that power of attorney. It's really easy to do. You just draft, it's like the document that you draft the power of attorney from. You appoint the revocation, and you send that revocation to all the agencies that are involved with them. The person that is the power of attorney is provided with the revocation. You've got, if the person has capacity, then they're able to do that. They can revoke that. Sometimes people, though, are like, well, I still want them to be my power of attorney. I just want them to stop.
Yes.
And that's more difficult, because essentially what they can do is just approach the bank directly and provide them with their bank or financial institution directly and say, I've got capacity. You need to stop dealing with this person. And again, you know, that is something that maybe it might be worth engaging with the solicitor about, if the person's got capacity to, or even we might be able to assist them if they're in our catchment, or a CLC may be able to assist them with just writing a letter saying basically cease and desist, stop. Here's the medical material confirming that I have capacity, and therefore you are misusing that power of attorney and you need to stop.
Sure. Thank you.
That is obviously, if that doesn't work and the person continues to do it beyond that, there are obviously that person can be sued for misusing the power of attorney. And as I said, sometimes in certain circumstances, there can even be criminal sanction in relation to that person can be charged with an offence. Generally, that's to do with guardianship. But yeah, so as I said, if My advice in those circumstances, if the person's concerned, just revoke their power of attorney. They can always reappoint them if they need to down the track. But as I said, if they've broken the trust by kind of not listening to the person when they say they've got capacity, then perhaps they're not the right person to be appointed as their power of attorney in the first place.
Thank you.
No
Hey,
worries.
Will. I've got a question about the will.
Yep,
So
sure.
if you design a will, you know how you can contest a will, right?
Mhm.
Can you put in your will, if people contest it, fight to oppose the being contested?
Yeah, so you can't necessarily you can preempt things. So you can say, well, I reckon they're going to fight about this. That's kind of what I mentioned before. They're going to fight about this. So I'm going to try and when I go to put my will together, I'm going to go to a lawyer and I'm going to say, I'm worried these two people are going to fight. What's the best way to structure things so they're not going to do that? How's the best way to write this so they're not going to have I'm going to limit the opportunities for those people to fight. There's only so much that can be done there. If someone wants to do that, they have the legal right to challenge a will. But as I said, you can really try and limit that. One of the reasons, and it's not just about in terms of people fighting over a will or challenging a will, it's not just about the family conflict as well. It's something I should have mentioned. When it comes to people challenging a will, often the legal costs for them doing that, in terms of the person that's representing the executor or the will, standing in the stead of the person who's passed away, the cost of that will come out of the estate often. So basically everybody who's a beneficiary is going to be a loser if there's in terms of they're going to lose value that they should have gotten from that will if there's a lot of challenges. So that's why, again, not just because you don't want family to fight after you pass away, but also you want the people that are going to benefit to get the most of their benefit. And so that's why it's really important to have a think about that. And if you do have, let's say, two sides of your family that just can't see eye to eye and just will fight over anything, it might be worth having a conversation with a lawyer and just talking them through that and saying, well, what can we do to try and minimize that? Can we make it really clear about who's getting what? And sometimes you might end up with a really long will that kind of goes through each individual thing that distributes them out item by item. Some people do that because they're concerned that if they don't, people will fight over all those things. But as I said, that would be my advice, is if you've got,
Thanks.
it would be to do that. So I can see that we've got perhaps one more question.
Can an executor be a beneficiary and be a decision maker? You could appoint however many, but could they all be the same thing? And what happens if one of them dies before you do?
Okay. So in terms of an executor can be a beneficiary, and often that's the case. Let's say if you only have one surviving family member and you appoint them as the executor and the beneficiary. So the executor can be a beneficiary of the will. The person that can't be a beneficiary of the will is the person that witnessed the signature. Okay. So that's again designed to try and prevent people being pressured into making wills. In terms of medical treatment decision maker, you can appoint multiple people as medical treatment decision makers. If you are going to appoint multiple people to any of these positions, as I said, you've either got to make sure that they get along, and or that you appoint more than two. You appoint odd numbers, so that if they've a contentious decision that they can't agree on, they can vote on it, and so that two you know, so if it's 2 versus 1 or whatever. Okay. Now you can obviously appoint the same person for all these positions. And there's no restriction on saying just because you're my executor means you can't be my medical decision maker and you can't be my power of attorney. You can appoint the same person for all those 3 things. And often people do, because a lot of the time, those 3 people will be their closest relative, whether it's their partner, their husband, their wife, whoever it might be, their partner, as I said, their brother, their sister, the person that they're closest to, they will appoint all these same things to, because, as I said, the key thing when it all comes down to in relation to appointing these positions is someone that I can trust to do these things for me. Okay. And not abuse that position. Okay. And so, as I said, in those circumstances, it really is important to choose. If it is the same person, as I said, that's fine. There's no restriction. And if you're going to appoint multiple people, make sure that, you know, that you are happy that they're going to get along and not cause disputes. And the third thing that I'd mention in relation to all those kind of appointments is you can also, with each of these, appoint alternatives. So if this person passes away before the will's executed, or this person is not available or declines to take up the role, there is an alternative person that can be appointed. Last thing, if the person is just doesn't exist or is not available, in terms of an executor, essentially generally what happens then is that either the court will appoint someone. So someone might put up their hand to be the executor, or someone might decide that they, or there might be no one. Then, as I said, the court can appoint someone to do that, to fill that position. With a power of attorney, obviously, if there's no power of, if the person's passed away or they're not available, then there's just no power of attorney. That's why you can appoint alternatives. And similar with the advanced care directive, because you don't have to have those things. You don't need an advanced care directive or appoint someone as a medical treatment decision maker. It just means that the medical treatment decisions will be just made by the doctors. Okay. And you won't have that control or that say. Similarly, with a power of attorney, if you don't appoint someone as a power of attorney, it just means someone will be appointed as your guardian, and you won't have a say. It'll just be decided by VCAT. Okay. So that's why it's important to if you want to have your say, even when you aren't able to anymore, that's why you want to appoint all these positions. So I'll leave it there.
Hey, Will, thank you for being such an engaging presenter on behalf of Brandon Who Matters. So thank you.
You're welcome. Thank you so much for having me.
Well, I'd like to ask you something before we finish up.
Cheeky, we've already thanked him.
No, I don't.
That's okay. One last question. We got a couple of
Cheeky,
minutes.
all right, you can go.
Can you just remind me to thank you later? I'd like to ask, firstly, you were talking before the start, you said you mentioned probate. And
yes.
Is that really, is that something we need to think of if we don't have enough access?
No. As I said, if you're, I think the value is, it's around $30,000. I think is the cutoff. It changes. Last time I checked. So if you don't have those kind of assets, or you don't own a piece of land or anything like that, or a house, then you probably don't need to worry about probate. Or if you're the beneficiary or executor of a will that has that, then generally you don't need to worry about probate. But as I said, it's so if that
So,
happens,
I need to
then
take
talk.
it.
Yeah, then I'd talk to a lawyer. So contact us or contact a community legal centre and say, this has happened. This is how much there is. Does that reach the threshold?
Right. Well, I need to take a chill pill. Well, being called Will, does that interfere with you talking about Will?
Wills? It absolutely does.
Okay.
I'm Will talking about wills. There you go.
Hey, Will, she's a little bit cheeky.
I figured as much. Well, I'm unfortunately I do need to log off, but I really do thank you, Lauren, and everyone for arranging this. It was an absolute pleasure to talk to you all, and perhaps we can do it again in the future if there's just get in contact with. I don't know, Lauren, did you get in contact with Kirsten? Or
I did, yes.
Yeah, get in touch if there's maybe next year or something or whenever. If I'm available, more than happy to talk to you all again.
All right. And you
Thank
also
you.
said there might be some written material.
Yes, I'll have to put that together. Should I just email that to?
That would be great, and I'll pass it on.
There's two separate documents. One in relation to wills, which just kind of goes through some of our common questions that we get. And the other is about advanced care's directive. A lot more detail in those notes. As I said, I kind of zipped through the stuff, especially in relation to the advanced care directive. So I'll send that through.
Now, it was a
Thank
great
you.
session. Thank you, Will,
Thank you
and
so
thank
much.
you everybody else for attending.
No
Thank you.
worries. Okay, take care.
Bye all.
Thanks.
See you later, guys.